And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not going to, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted. I brought him, I should state it this way, he is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being we all would expect, have not been followed. It's evidently made, let me restate that, it is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder, he got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted, so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence.